All right, let's take you now to our leading story. The Competition Commission says if the 8 insurance companies under investigation for price collusion are prosecuted and found guilty, consumers may be able to claim for damages against the companies. The Commission obtained warrants to conduct search and seizure operations at the premises of 8 insurance companies, including Old Mutual, Brightrock, Discovery, Hollard and Sanlam in Gauteng, KwaZulu-Natal and the Western Cape. Now, let's discuss this further. We're now joined via Zoom by Ahmore Burger-Smidt, a director in the competition law practice at Werksmans Attorneys. Ahmore, thank you so much for your time this afternoon. Perhaps let's start here. What led to these raids? I mean, does the Commission, if we look at the legalities, have some level of prima facie evidence to have convinced a judge to issue a warrant for the search?
Afternoon, and thank you for having me. And that is such an important question, because in order to obtain a warrant, the Competition Commission go on affidavit and make out a reasonable case for a judge to then issue the warrant for the Commission to conduct these raids. So where we stand and what we do know is that a judge deemed the evidence under oath presented by the Commission as reasonable for the Commission then to conduct these 5 raids up in Johannesburg, then in Durban, and 2 in, or 8 raids, two in the Western Cape. And what that reasonable evidence would be, we won't know, because the Competition Act makes specific provision that while an investigation is underway, the information is deemed as restricted information. So we won't know at this stage what that is.
And when you look at the companies, and perhaps, you know, for the benefit of our viewers, I need to mention the 8 because we mentioned a few in our intro. Brightrock Life, Discovery, FMI, which is a division of Bidvest Life, and Hollard, Momentum, Old Mutual, Insure, Professional Provident Society, and Sanlam. Should these companies be found guilty, what penalties do they face? I mean, we do know currently they stand accused of sharing, as you said, sensitive information which could manipulate insurance prices, and we know, of course, that that is prohibited in this country.
You know, we need to take into consideration the mere fact that a raid has been conducted does not make these companies guilty. This is a fact-gathering and an evidence-gathering exercise of the Competition Commission, and the Commission will still have to go through these evidence and in order to evaluate it, the information they gathered, to see whether they've got sufficient evidence to then make out a prima facie case to prosecute these companies. If these companies are indeed found guilty of cartel conduct, they can face significant fines. And then the first hurdle that we look in terms of in fines is an up to 10% fine of their annual turnover. And this is a significant amount. Now, one know, and we as competition law practitioners are well aware of the fact that the Commission always seek the maximum fine. That does not mean that the Competition Tribunal will in itself award such a high fine, because various factors can be argued, and there is a formula that is taken into account in order to calculate fines then. So mitigating factors can be argued. But I think the important thing for consumers out there to realize is that the raid in itself does not equate to they are guilty. I have spoken about this extensively, and the one thing is for sure, we know that if companies take decisions independently based on publicly available information, that does not constitute cartel behavior. It's only when they agree on certain price increases or the structuring of products that would be deemed a price fixing or the fixing of a trading condition. But one has to assume that at least there's a reasonable indication at this stage that something seems to be wrong, and the Commission has then embarked on this process to investigate that.
Now, you know, when we talk about customers and clients, of course, somebody watching this very concerned about what is at stake for them. How are customers or clients likely to be impacted? And of course, what recourse then is there for clients? And of course, we are speaking, you know, in the likelihood of these companies being found guilty.
You know, we consider cartel behavior as one of the worst criminal acts that can actually occur. And it impacts directly on the price that a consumer pays, and it also impacts on the quality of a product. Because if competitors agree on how they will put products together or the prices, at the core and at the end of the day, it impacts consumers on those two levels, the quality of the product and the pricing of the conduct and of the product that they'll pay for. The Competition Act provides that consumers can institute class action for damages. Now, the first class action suit we've seen that was fought and didn't really move anywhere was in the bread cartel. And the Commission refers to this fact that, consumers can claim damages. That is what the competition authorities are talking about, instituting class actions to actually then recoup damages that they might have suffered. But that is a very difficult case to be proven, and it must be, you have prove real damage that you've suffered as a result of the conduct then that companies will be found guilty of. The first hurdle for companies in this regard would be the administrative penalty that the competition authorities can impose. And we mustn't forget one other thing, that the Act provides for criminal sanctions as well. So the landscape has become very complicated in all these aspects, but consumers themselves would worry about, have I been paying? I see price increases coming through on premiums. Am I paying too much for products? Why are products being adjusted? But as I've indicated, if companies have made changes and have done that independently based on their actuaries having done calculations on their own pricing structures and cost structures and market conditions independently, that does not in itself mean that they've engaged in cartel conduct. So it's not immediately, one shouldn't immediately jump to the conclusion that these companies are guilty. But yes, the Commission does have a reasonable suspicion that something is wrong here.
And in fact, they said they have a very strong case. Let's leave it there for now, but thank you so much for unpacking all of this for us. Thank you so much. We appreciate it.